This courtroom hearing starts with a serious request. A woman facing 3 criminal cases and a total bond of $250,000 is asking the judge for a reduction. But here's the twist. While the defense hopes to convince the court she deserves a second chance, the prosecution is firmly pushing back, with charges that include intoxication, assault, injury to a child, and aggravated assault with a deadly weapon. The stakes are extremely high. The big question now is whether the defense can prove she actually qualifies for a lower bond, or if the judge will shut the request down entirely.
State's ready, Judge. Defense is ready, Judge.
All right, the court is calling 2026 CR 0000214 and 2026 CR 0000217 and 2026 CR 0000096. State versus Courtney Price. Could I have parties announced?
Brandon Prada for the state.
And Rick Pena for the state.
And Richard Garcia for the defense. Ready.
And are you Miss Price?
Yes.
All right, your attorney has filed in each of these cases an application seeking a bail reduction, and the cause number ending in 14. Your bond is set at $100,000, and the cause number ending in 17. Your bond is set at $100,000, and the cause number ending in 96. Your bond is set at $50,000. So, state, are you opposed to the bond reduction in each case?
We are, Judge.
Yes, you are.
All right. Defense, do you have any witnesses?
No, Your Honor, we do not. I would call Courtney.
All right. Ms. Price, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. Could you state your name for the record? All right. You may proceed.
Thank you, Judge. Ms. Price, can you tell the judge why your bond should be reduced?
I feel like it's my first time receiving a felony. I do have good intentions when I do be.
I'm sorry, what?
I do have good intentions if I am able to be reduced on bond. I plan on getting out, getting a part-time job, taking AA classes, parenting classes, getting in some type of counseling or therapy, just to rehabilitate myself, get back on track. This is my first time receiving a felony. It was never my intent.
No, let me stop everybody right there. Let's go off the record for a moment. So here's the thing, and I don't know how people are going to ask their questions, but if you're intending to talk about the alleged facts of this case,
Yes, ma'am.
then the state has a chance to question you about that. I'm only here to determine what a bond amount should be set. And usually what I can tell you, when people are requesting a bond reduction, usually this is how much the bond is. This is how much I can afford to pay. I'm not a flight risk, and whatever they want to provide. But if you start talking about the facts of the case, what you think the facts are, then the state is allowed to question that. I'm just letting you know that. But if you want to do that, then you can do that. But now you know.
Yes.
Otherwise, when you're being questioned, the state is not allowed to ask you about the facts of the case or what they think the facts of the case are, because I'm only here to decide if your bond should be reduced or not.
Right. So, Ms. Price, can you tell the judge how long you've been incarcerated?
October 19th, it'll be 4 or 5 months.
And does your family have the means to pay the total of $250,000?
No, sir.
And does your family have any means to pay any amount for these bonds?
Yes.
And can you tell the judge how much?
I don't have a precise number at this time, but I would like to see what I'm able to get reduced.
And you have spoken with the bondsman?
Yes.
And the
My
bond
family has.
and the bondsman's waiting to see what the outcome is today?
Yes, because they've seen that I've had the court date for the bond reduction, so they like to see what could be reduced and then be able to work something out.
And you are willing to be placed on house arrest?
Yes, I don't believe I'm a flight risk, but whatever the judge sees necessary, I have no problem with that.
And you do have children?
Yes,
And the children are living with your godparents?
yes, 2 of my children are living with my godparents. My smaller child, she's living with her father.
And if you are able to bond out, where would you be living?
I would like to live with my godparents, but if other arrangements need to be made, that can be done as well.
Okay. And did you have a job before you were incarcerated?
Yes, I worked at San Antonio Behavioral Hospital,
And how long were you there?
2 years.
And so you're asking the judge to reduce the bond, whatever she thinks is just and fair?
Yes, sir.
Thank you. Pass the witness.
Just a few quick questions, Judge. Ms. Courtney, let me ask you, does your family, do they have any kind of real estate or home ownership they can put up as collateral?
No.
So everybody rents, nobody owns any kind of property?
Yes, sir.
Okay, what about vehicles? Does anybody own their vehicle?
No.
Okay. Let me ask you, when were you last arrested for DWI before this?
October 2nd, 2022, I believe.
Okay, what was the resolution of that case?
Deferred adjudication probation.
Okay. And are you aware that right now you have 3 cases?
Yes, sir.
And that would be actually multiple counts. One is intoxication assault, causing serious bodily injury, abandoning or endangering a child, driving while intoxicated with a child under 15 years of age, injury to a child, and aggravated assault with a deadly weapon. Would that be all the counts against you?
Yes, sir.
Okay. And Judge, I believe we'd like to admit the police report for your review on state exhibit number 1.
Any
Pending any
objection? Any objection?
Judge, I would object to hearsay.
Judge, under the rules of evidence, this is a pre-trial procedure, and the rules of evidence exempt these kind of proceedings from the rules of evidence.
Yes, that's correct. That'll be overruled.
Thank you, Judge.
All right, the court will accept into evidence State's Exhibit number 1 and it for purposes of this hearing only.
Thank you, Judge.
Have you seen it?
No, but
It's in this
I have seen it.
Anything else?
Nothing further, Judge.
All right. So this is what I'm going to tell the parties. I really can't make a decision on her motion for a bond reduction because I haven't been presented with any evidence on what amount she can make. So I don't have anything to base it on. So if y'all would like, this can be rescheduled for Monday. And if if someone has some evidence on the amount that she's able to make, because it appears that she's unsure based upon the testimony. So I don't have anything before me to suggest
Well, she
what
hasn't
amount
worked
she
in,
would be able to make.
she hasn't worked in 4 months and her family, as you heard. I don't even know how they're gonna come up with any amount. So it's,
I mean, I need something, so I have a basis to go. I'm not saying I'll reduce it, but if somebody, somebody were to tell me, oh, I can make 60,000, but I don't have anything before me on any type of bond amount she thinks she's able to make.
And Judge, if I may, with all due respect to defense counsel, it is their motion and they do have the burden to prove up this to the judge. And so with all due respect, they failed to prove up their motion. We ask that you deny their request to reduce bond.
Well, I mean, I'm not going to necessarily deny the motion at this time. I think what we're going to do is we're just going to recess the hearing. And then counsel, if you have more information to submit to the court on Monday, or if you want to have information submitted on Friday, that would most likely have to be done with Judge Nahara, Judge Halstead. But otherwise, I can recall this back on Monday to continue this hearing. And if there's no objection from the state, if her relatives want to testify by Zoom, they can testify by Zoom. No, they said they have no
No
objection.
objection, Judge.
And if you want to, if they're able to Zoom in today, I'll take it up today. But I don't have enough information to reduce the bond at this time.
okay.
So Do you want
Monday.
to see if you want to do it Monday or you want to see if they
Monday,
can zoom
because-
in now?
I would need to locate them and,
Okay. All right, so Ms. Ferguson, we're going to recall Ms. Price. We're going to recall you back on Monday so I can have more information and make an informed decision on your motion, okay?
Okay.
All right, thank you.
thank you.
You're welcome.
This hearing highlights an important reality about bond reduction motions in court. The judge isn't deciding guilt or innocence here. The only question is whether the bond amount should change. And in this case, the defense simply didn't provide enough concrete evidence about what amount the defendant or her family could realistically pay. Without that financial information, the judge couldn't justify lowering the bond yet, which is why the hearing was recessed rather than denied outright. It's a reminder that in court, details and proof matter just as much as arguments. Even when someone asks for relief, the burden is on them to provide clear evidence supporting that request. But what do you think? Should the judge eventually reduce the bond, or do the charges make the current amount reasonable? If you found this case as shocking and interesting as we did, make sure to hit that like button, share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns